Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is the Compliance Playbook, our first quarter 2025 compliance review. While I'm a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. That said, pick up your phone and snap that QR code to follow me on LinkedIn, where I post compliance-related content weekly. Before we begin, I want to cover a few housekeeping items. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information will be emailed to you next week. We are not providing copies of the slides we're presenting today. However, when we send out your credit information next week, we'll send you an email with a link to a recording of this webinar session. If you are experiencing any audio or video issues, please refresh the browser window by clicking F5 on your keyboard or send us a message using the Q&A icon at the bottom of your screen. Carrie and Doreen are producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, we'd appreciate getting your feedback. Please take our brief survey and let us know if this session was helpful. My focus is to create sessions that are meaningful, so we welcome ideas for future topics. So again, please take 60 seconds out of your day and let us know what you think. And again, please press F5 on your keyboard to refresh the presentation anytime you experience any audio or video problems. I should also mention that today we're continuing our live and after hours Q&A session. My colleague, Nicole Campion, will be answering your questions live during this webinar, and we're hosting an after hours session after the presentation to recap your questions and get to any questions that we couldn't cover live during the hour. So stick around after the show if you can and get your questions in using that Q&A icon. We want to make today's discussion interactive. We've just wrapped what I'd call a whirlwind of a quarter. Across the country, lawmakers pushed forward legislation that could significantly reshape how employers approach background screening and hiring. We saw movement on fair chance and clean slate laws, proposals to eliminate pre-employment marijuana testing, and a continued push for pay equity with new transparency mandates. At the same time, AI and privacy laws are gaining traction, with states proposing and in some cases passing restrictions on automated hiring tools. And in Washington, D.C., immigration enforcement is back in the spotlight, putting pressure on employers to revisit their I-9 and E-Verify compliance strategies. It's a lot to digest, but that's exactly why we are here. So let's cut through the noise and take a look at today's rundown. I'll provide you an overview of the current state of the law and offer some practical guidance to help you comply or prepare for compliance with these laws. As always, we've got a lot of ground to cover, so I'm going to be keeping a quick pace through these topics. This won't be an in-depth discussion of any single issue, but it will give you a solid foundation to build on. And if you click on the resources icon in this webinar, you'll find links to materials that can help with your compliance journey. In fact, I've written a companion piece of this webinar. It's the Compliance Playbook, Key Employment Law Changes for Background Screening in Q1 2025. Take a look at that document in the resource library for this webinar. It's really a good document for note takers, and it covers most of today's topics. And you're getting a sneak peek. I'm using this piece for an article that'll be published on Forbes this Friday. As always, I'm looking to create content that benefits you. So when you complete the survey at the end of the webinar, let me know what you'd like me to focus on in future webinars. So settle in for the next hour. Remember, if you have any questions, use the Q&A icon. Nicole's going to answer them live, and we're going to keep this conversation going during our extended Q&A after the presentation. As always, we're going to kick things off with a broad discussion concerning criminal history reform. Let's start with a high-level view of clean slate laws across the United States. These laws allow certain criminal records to be sealed or expunged from public view once someone has remained crime-free for a set period. The goal here is to reduce the stigma of criminal history and improve access to employment opportunities, obviously so folks won't recidivate. So for employers, the key takeaway is this. If a record is sealed or expunged, it's no longer visible in court indexes, which means it won't appear on a background check. Again, if a record is sealed or expunged as a result of a clean slate law, it's not available in the court indexes. It won't appear on a background check. On the map, you're going to see that every state except for Wisconsin offers some form of record relief, ranging from broad expungement of misdemeanors and felonies, those are in red, to more limited eligibility for specific offenses, those are in orange or that terracotta color. States marked with a star offer automatic relief, meaning that the process happens without the individual needing to take any action. In other states, individuals must petition the court for expungement. As I mentioned, Wisconsin is the outlier. While Wisconsin allows for judicial pardons, it doesn't seal or expunge criminal records. If you want to dive deeper, we've included links to our guides, Automatic Criminal Relief Volumes 1 and 2 in the webinar resources. It's a great resource that my colleague Nicole put together for you. Now let's take a closer look at clean slate laws taking effect in 2025, starting with Minnesota. The state's new law allows for automatic expungement of certain offenses like petty crimes, nonviolent misdemeanors after 5 years, and even some felonies after 8 years. Crimes involving violence, domestic abuse, or sexual misconduct are excluded. That's true for most clean slate laws. Although Minnesota's law went into effect at the start of the year, expungements, they're not going to begin until mid-May. The delay is due to the complexity of running expungement logic against millions of records and more than 16,000 statutes in the state. If you can imagine trying to remove those records and find records that are applicable, it's a highly technical thing that is causing delay for implementation until mid-May. So some outdated records may still show up on background checks. In the meantime, employers should be prepared to adapt their screening programs as those records start disappearing. Next up, Colorado, where the state began implementing its clean slate law in July 2024. It provides automatic sealing for civil infractions after 4 years, misdemeanors and petty offenses after 7, and starting mid-2025, July in fact, eligible felonies after 10 years. The state publishes quarterly eligibility lists, so employers can expect older convictions to gradually appear from reports. If you're interested in those quarterly eligibility lists, I link to them in that companion document I referenced at the top of the webinar. In Virginia, Clean Slate was signed into law in 2021, but won't go live until July 1st, 2026, unless the state can complete upgrades to its expungement technology more quickly. The law provides for automatic sealing of certain misdemeanor convictions and dismiss charges that occurred after January 1st, 1986. More serious offenses like Class 5 and 6 felonies or deferred dismissals, they still require a petition. For the first time, ancillary matters such as probation violations and failures to appear can also be sealed. And finally, in Washington, D.C., the Second Chance Amendment took effect this year. Starting January 2026, offenses that have been decriminalized or ruled unconstitutional, like marijuana possession, for example, will be automatically expunged. Other misdemeanors and non-convictions will be sealed after 10 years unless excluded. Those are things like DUIs or domestic violence charges. And dismissed charges can be sealed immediately. Misdemeanor convictions can be petitioned for sealing after 5 years or 8 years for felonies. And here is what we're tracking. Several states have proposed expansions to their laws to make record relief more accessible, either by introducing petition-based options for individuals who don't qualify automatically, or by refining existing processes to improve eligibility and implementation of these clean slate laws. States like California and New York are filling gaps by allowing people with more serious or overlooked offenses to petition for relief. Meanwhile, Michigan is fine-tuning its process to improve consistency and usability of its clean slate law. Other states like South Dakota are entering the clean slate space or adding targeted relief such as automatic sealing for marijuana possession. While Hawaii's proposal remains unclear on its process, specifically in Hawaii, their bill, for some reason, doesn't identify if qualifying offenses are sealed or expunged automatically or by petition. This is an example, in my opinion, of bad drafting, and it really highlights how this kind of vague legislation can create compliance challenges for you employers. I should mention that in the resources section of today's webinar, I've included a link to all of the legislation that we tracked in March. So if you're interested in a deeper dive into any of the bills that I'm covering, take a look at that resource. It's also the basis for all of these legislative monitoring maps that you're going to see throughout today's presentation. So check out that resource. And here is a look at the ban the box landscape impacting private employers across the United States. In all of the jurisdictions shown on the map, employers are prohibited from asking about criminal history early in the hiring process, typically during the initial application or before a conditional offer. In states indicated in that red text, these restrictions apply broadly to all paid roles, including contractors and gig workers. So again, if you pay somebody to do a job, they are included in the scope of the ban the box law. Gig workers, I'm looking at you. But not all ban the box laws are the same. Some jurisdictions require specific pre-adverse notices identifying the criminal conduct that could disqualify a candidate. Those are shown in aqua. Others go further, requiring employers to conduct and share an individualized assessment that explains how a past offense relates to the role. Those are in that blue column. Then you have cities like Los Angeles and New York City in wine, which require additional city-specific forms as part of the pre-adverse process. There's also a group of jurisdictions like Louisiana, Atlanta, Madison, and Wisconsin that don't ban the box outright, but still required individualized assessments before making a decision based on criminal history. That's as part of a fair chance ordinance in those jurisdictions. As a reminder, this assessment, this individualized assessment, weighs the offense against the responsibilities of the job. You don't always have to share that assessment with a candidate unless the law says that you do. But the bottom line is that compliance isn't one size fits all. You're going to need to tailor your adjudication, pre-adverse, and adverse action process to meet local requirements. To help with that, HireRight offers a free compliance workbench tool that can help guide you through your ban the box obligations. You'll find more information in the resources section, including our ban the box white paper. And if you're a HireRight client, check out Compliance Central within Screening Manager, where you'll find sample individualized assessment templates, pre-adverse and adverse action templates, all of those available for your reference. Let us know if you need any help finding those documents. Let's turn to Kansas City, Missouri, where a new ordinance took effect earlier this year. It adds criminal history status as a protected characteristic under the city's civil rights code. It's a nod to the growing fair chance hiring movement. Again, criminal history status. You can't discriminate against an individual based on their criminal history status. The ordinance prohibits the city from discriminating against applicants based on criminal history, and it requires individualized assessments that consider the nature, severity, timing, and job relevance of the offense, as well as any disqualifying legal restrictions. But for private employers, things are less clear. While the ordinance updates anti-discrimination rules for businesses with 6 or more employees and defines criminal history as a protected class, it doesn't explicitly require private employers to conduct individualized assessments or restrict how they use criminal records. That ambiguity creates a gray area and potential risk if the city later expands how the law is interpreted or enforced. Now, you might remember that Kansas City already has a ban the box ordinance for private sector employers. It was passed in 2018, and it delays criminal history inquiries until after a candidate is selected for an interview. But it doesn't require individualized assessments, making this new law a possible shift in expectations on employers. So what's the smart move here? What should you do? Even without a clear mandate, conducting individualized assessments is always a best practice. It aligns with EEOC guidance, that's the Equal Employment Opportunity Commission guidance. It helps reduce legal risk, and it shows a commitment to fair hiring. So if you are a private employer in Kansas City, now is the time to review your background screening policies, consider integrating individualized assessments, and ultimately consult your legal counsel to prepare for future clarification or enforcement of this ordinance. Let's take a quick look at how the Wisconsin Fair Employment Act, the WFEA, compares to Madison, Wisconsin's local ordinance when it comes to using criminal convictions in hiring. This isn't a ban the box situation per se. Neither law restricts when employers can ask about criminal history. Instead, both focus on how that information is used once it's disclosed. Under the WFEA, employers can't reject or fire somebody based on a conviction unless it's substantially related to the job. That means that there has to be a clear connection between the nature of the offense and the duties of the role, like working with vulnerable individuals or handling money. Employers also can't consider arrest records unless the arrest has resulted in a pending charge that's substantially related to the job. Now, here is where Madison's ordinance differs. Until recently, Madison had a stricter rule. Employers couldn't consider offenses older than 3 years, even if job related. But that rule has been repealed to better align with state law. However, Madison still adds a unique layer. Employers must now consider the applicant's character when evaluating a conviction. What exactly counts as character isn't defined. So that again introduces some uncertainty or ambiguity into this whole process. In practice, I think character could mean factoring in whether an individual has had steady employment, their rehabilitation efforts, or maybe strong professional references since the conviction. So here's the takeaway for employers. If you're hiring in Madison, it's smart to document how you're weighing rehabilitation and conduct, especially when a conviction might otherwise be disqualifying. So complete those individualized assessments anytime you're considering somebody with criminal history in Madison or in Wisconsin in general. This is becoming a more frequent topic of litigation. So again, revisit your hiring processes in Madison and Wisconsin in general anytime you're reviewing criminal history of an applicant for employment. Let us know if you have any questions about that. Now, let's turn to Ban the Box, which remains a central focus in Fair Chance hiring efforts nationwide. In 2025, we're seeing what I'd consider a mix of activity. There are some states introducing Ban the Box for the first time, others moving to strengthen existing laws. You can see what's new on the screen. This is a map that I put together for you. In Washington may require employers to identify potentially disqualifying offenses and conduct individualized assessments. That requirement to conduct individualized assessments would be new. Oregon is looking to expand coverage to employment agencies. Currently, it only applies to employers, not just not just looking at private employers, but also employment agencies. Texas is considering a statewide law building on local ordinances in places like Austin and DeSoto. And New York State could expand its human rights law, pushing boundary checks to post offer while preserving stronger local protections like in cities like New York City. So again, big statewide measures being considered in New York and Texas. Those would be completely new to us. What's, I think, especially noteworthy, if you look at this map is the momentum in what I'd consider conservative leaning states like in Alabama, Kentucky, and South Carolina. So this is a sign that bipartisan support for second chances is growing. So why does all of this matter? These proposals reflect a shared understanding that employment is key to successful reentry for criminal ex-offenders. As more states join the movement, employers need to be ready to adjust when and how they consider criminal history during the hiring process. Again, you can check out our legislative monitoring document if you want to explore any of these bills in greater detail. So let's wrap up this section with a few actionable takeaways from the Compliance Playbook on criminal history reform. First, review and update your screening policies. Clean slate laws are now active in Minnesota, Colorado, and Washington, D.C., with Virginia's law expected in July 2026. Each state has its own timeline and criteria, so accuracy in applying these clean slate measures really matters. Also remember, there's often a delay between a law's effective date and when the records are actually sealed. Courts may need time to process those changes, so be prepared to handle questions from candidates whose records are technically eligible for sealing or expungement, but still appear in background reports due to backlogs at the court. Second, stay alert to proposed legislation. Many states are moving to expand both automatic and petition-based relief. If those pass, you'll need to reassess your risk mitigation strategies. You might want to look at alternatives like professional references or social media screening to close those gaps when fewer records are available. Third, keep an eye on gray areas. We've talked about those today, like Kansas City's ordinance, which protects criminal history status but doesn't clearly apply to private employers. Even without firm requirements, the compliance expectation is there, so conduct those individualized assessments. And finally, invest in your hiring teams. With individualized assessments and notice requirements expanding, recruiters and HR need to understand how to apply these rules consistently and compliantly. If you are a HireRight customer, take advantage of the tools we make available to you. There's Compliance Workbench, which helps manage ban-the-box obligations. You can look at criminal search depths. Things like variable unlimited search depth options go beyond the 7-year convictions reporting standard. There's also managed adjudication and adverse action solutions to help streamline your processes. The criminal history landscape is evolving quickly, but with the right strategy, you can stay ahead of those changes. Keep getting your questions in using that Q&A icon. Check out the resources section. We've included companion articles for everything that we've covered so far. And if you need help updating your account or your processes, let us know in the survey. We are here to support you. So let's shift gears and talk about pay equity measures. At their core, pay equity measures aim to ensure equal pay for equal work. A common feature of these laws is a ban on asking candidates about their previous compensation, at least after a specific point in the hiring process, if at all. Pay transparency measures, on the other hand, they require employers to share pay ranges with candidates and in some cases with current employees. These laws are designed to create greater visibility into compensation and to help close those wage gaps. And here is a map I created that highlights the 29 cities, counties, and states that have enacted salary history bans. Again, what these laws mean is that you can't ask a job applicant or candidate about their past compensation or use their compensation history to set their future pay. But here's some good news. You can still ask about their salary or pay expectations. For example, as of now, asking, what do you expect to make in this role is permitted 100% of the time. More on that in a minute. And here is another map for you. It highlights the jurisdictions requiring employers to either post or provide a salary range for open positions. Most pay transparency laws specify that the range you share should reflect what you reasonably expect to pay for the role. These measures aim to ensure candidates and employees have clear insights into compensation expectations up front. Let's take a look at a table that breaks down pay transparency laws effective in 2025. Illinois and Minnesota began enforcing their pay transparency laws on January 1st, each requiring specific salary and benefit disclosures with varying thresholds for employee count. Massachusetts pay transparency regulations for larger employers will now include demographic reporting requirements. I'm going to cover that next. That's effective July 31st, 2025. New Jersey and Vermont introduced additional pay and benefit disclosure requirements later in the year. Vermont's law is especially detailed, requiring commission structures and tip wages in the postings. Let's now quickly circle back to Massachusetts and talk about pay data reporting. Massachusetts is introducing new requirements for employers with 100 or more employees. As of February 1st, 2025, these employers must annually report aggregated wage by race, ethnicity, sex, and job category as a supplement to their EEO-1 report. Public employers, unions, and school systems with the same employee threshold will also need to report this data, though only every 2 years. The state's going to publish aggregated wage data reports. However, those reports are not going to identify individual employers. Keep in mind that similar pay data reporting laws are already in effect in California and Illinois. So Massachusetts is joining a growing trend in wage transparency and equity with their pay data reporting law. As of April 9, 2025, Ohio employers will be required to provide detailed wage statements under a new law. This law applies to all employers and outlines what must appear on employee pay stubs. For salaried employees, name and address, employer name, gross and net wages, any additions or deductions, the pay period, and the payment date. Pay stubs for hourly employees must also include total hours worked, hourly rate, and any overtime. While this isn't a pay transparency law, it does create a new layer of wage accountability. What's interesting to me is that failure to comply could lead to complaints and in some cases, public posting requirements. That's right. In Ohio, there is a public shaming of employers that don't comply with this law. This could obviously impact your reputation, so you want to make sure that your pay stubs are aligned with Ohio's pay stub law. Cleveland is the latest city in Ohio moving toward pay equity with a proposed ordinance that would ban employers from asking about a candidate's salary history, using it to set pay, or retaliating against those who don't disclose it. But the proposal doesn't stop there. Unlike Columbus, Cleveland would join Cincinnati and Toledo in requiring pay ranges in job postings. This is a clear shift towards greater pay transparency. The ordinance would apply to employers with 15 or more employees, including those hiring for temporary, part-time, or commission-based roles, and would take effect 180 days after enactment. Enforcement would fall to the city's Fair Employment Wage Board, with fines ranging from $1,000 to $5,000 depending on prior violations. If enacted, Cleveland would become the fourth major Ohio city to restrict salary history questions and further expand the state's local patchwork of pay equity. Interesting that there isn't a statewide measure. Instead, it's been left to the cities to figure this one out. Now, here's what we're monitoring. Let's take a quick look at state-level pay equity efforts that are shaping up in 2025. Several states have introduced new pay transparency or salary history bans this year, signaling a continued momentum for pay equity nationwide. Here's an overview. West Virginia, the only state in red, is proposing a pay history ban. States in teal are proposing pay transparency laws, and states in red and teal stripe are proposing comprehensive pay history bans that include pay transparency. All in all, it's a strong reminder that the push for transparent, equitable pay practices, it's far from over. Most certainly a nationwide trend, and employers should be tracking these developments closely. We will, of course, continue to keep you updated. As part of our compliance playbook recap, here are the key actions for employers. First, audit your job postings. New or upcoming pay transparency laws in Illinois, Minnesota, New Jersey, Vermont, and Massachusetts require employers to disclose pay ranges and, in some cases, benefits right in the job ad. Second, avoid asking about salary history. If you're hiring in states or cities with pay history bans, you can't request or rely on past compensation to set offers. And be prepared. Cleveland and other cities are considering new bans that may be adopted later this year. I didn't mention this, but New York State is actually considering a bill that would prevent employers from asking about salary expectations. That's right. You couldn't ask an individual what they expect to make in the role. It'd be interesting to see if that one crosses the finish line. I'll keep you updated on that one. Moving on, prepare for expanded pay data reporting, especially in Massachusetts, which now joins California and Illinois in requiring demographic data in pay disclosures by job category. And fourth, don't forget Ohio's new pay stub disclosure law. It takes effect April 9th and requires detailed information for all employees with additional fields for hourly workers. Remember, monitor emerging bills in states like West Virginia, Oregon, and Alaska. These proposals could reshape your compliance strategy with new transparency or salary history rules. For more details, visit the resources section of this webinar to access our Pay Equity and Transparency ebook. And don't forget to send in your questions using that Q&A icon on your screen. Just a quick note for HireRight customers, our platform by default does not ask candidates to disclose their compensation history, so no worries about that. This area of pay equity, pay transparency, salary history bans, it's moving very quickly, so now is the time to get ahead of it. Let's pivot into a discussion about cannabis reform. You're going to hear me use the terms cannabis, marijuana, and THC interchangeably. They are the same thing. I tend to do the same in my writing. So again, cannabis, marijuana, THC, they are all the same. Don't let that confuse you. Let's kick off this section with a look at medical cannabis accommodation requirements. On the map, the red states generally do not require employers to accommodate medical cannabis use. The aqua states have anti-discrimination laws that require reasonable accommodation. What this means, reasonable accommodation, it means that employers may need to make adjustments to help employees perform their jobs unless doing so creates an undue hardship on the employer. The blue states are silent on the issue of accommodation. And then there is Philadelphia and Pittsburgh shown in purple, which takes it a step further by prohibiting pre-employment marijuana testing altogether. Again, no pre-employment marijuana testing in Philadelphia and Pittsburgh. One important reminder: in all jurisdictions, federally regulated and safety sensitive positions are typically exempt from these requirements. So make sure your policies are aligned with applicable state and local laws to stay compliant. Let's talk about Kentucky, where the state's new medical cannabis program took effect at the start of the year. For employers, not much changes. The law doesn't require you to accommodate cannabis use on the job or off, especially if it leads to workplace impairment. You still have broad discretion to enforce drug-free workplace policies that align with your business needs or contractual obligations. Importantly, the law does not create employment protections for medical cannabis users. Employees can't sue you for wrongful termination simply by being patients, and they may be ineligible for unemployment if they violate your workplace policies. So, in short, your policies still rule the workplace, so make sure they are current and consistently applied. And here is our recreational map. As you can see on the screen, 23 states and DC have legalized recreational cannabis, also known as adult use legalization. In red states, recreational cannabis laws do not impact employer drug testing policies. However, states in aqua limit the ability to take action based on a positive marijuana test. And in blue, states like California and Washington pre-employment testing for non-psychoactive THC metabolites is prohibited. So again, in California and Washington, shown in blue, pre-employment testing for non-psychoactive THC metabolites is prohibited. This means that you either need to remove THC from your drug testing panel or switch to oral fluid screening in California and Washington. And in states like New York and Minnesota, shown in purple, pre-employment cannabis testing is generally banned unless specific exceptions apply. One quick update from Delaware. The state's adult use cannabis market was expected to launch this spring, but regulatory delays have pushed that back. What's the issue? Well, the FBI rejected Delaware's application to run fingerprint based background checks for cannabis licensees, citing missing statutory language. So, lawmakers are working on a fix, but the licensing process is on hold and the market launch is likely months away. Importantly, Delaware does not offer employment protections for recreational cannabis users. Employers can continue to enforce drug-free workplace policies and take action on positive marijuana test results. Again, while Delaware has legalized recreational marijuana, there's no actual commercial market for it yet. And here's what we are monitoring. Let's take a look at some cannabis-related legislation that we are tracking in 2025. Legalization, as you probably know, remains a very hot topic, with multiple states proposing bills to expand adult use or medical cannabis programs. One proposal in Massachusetts stands out. I want to cover that quickly. While recreational cannabis has been legal in Massachusetts for years, a new bill would ban most pre-employment marijuana testing even after a conditional offer of employment. Here's the tricky part. The bill allows testing post-offer but prohibits making it a condition of employment, raising questions about how it would work in practice, right? If you can test, but you can't actually take the results, use the results of that test as a condition of employment, then why would you test at all? Again, a unique, I think, drafting issue with Massachusetts bill. I'm going to keep monitoring that one for you. So if passed, Massachusetts would join places like New York, Minnesota, Philadelphia, and Pittsburgh in restricting pre-employment marijuana testing. Employers would need to pivot to impairment-based policies and rethink zero tolerance models. Now it is time for my favorite part of the show. This is audience participation time. If you've attended my other webinars, you know that I'm going to ask you to be the judge. So this one is called Blunt Truths in the Workplace. You're going to hear the facts, the complaint, and then you're going to be the judge in a question I'll ask on the next slide. You'll answer the question in a poll. So imagine this. You've been a firefighter, paramedic, EMT for over a decade. You've responded to hurricanes, house fires, heart attacks. You've earned a promotion and sacrificed holidays to serve your community. Like many high-stress roles, you deal with anxiety and insomnia. And after trying prescriptions that left you foggy or detached on the job, your state licensed doctor recommends medical marijuana. You follow the law, you get your medical marijuana card, and you use it only off duty. Then in 2019, you're selected for a random drug test by your employer, the county. There's no incident, no complaint. It's just routine random testing. The result, of course, it's positive for marijuana. But you're prepared. You hand over your valid medical marijuana card. You explain your treatment. You cite your employer. That's the county's policy, which allows lawful prescriptions to explain positive test results. Seems pretty straightforward, right? But instead of treating this like Adderall or Xanax or any other antidepressant drug, the county, they suspend you without pay. There's no second test, no allegation of impairment or misconduct. They simply say federal law still considers marijuana illegal. So what do? You sue. Your claims, disability discrimination, violation of workplace policy, and that your use of legal medical marijuana in Florida should be treated like any other off-duty prescription. So those are the facts. Now, your turn. You be the judge. What do you think? Did the county violate the law? I'm going to give you a few seconds to get your answer in. Yes or no. Did the county violate Florida law by disciplining the firefighter EMT despite his medical marijuana card and off-duty use? We have around 1,000 of you on today's call. A little over 1,000 of you on today's call. So once we get about 50% of you in, I will go ahead and move on. We're at about 20% of you. So keep getting your answers in. Again, yes or no. 40%. Don't be shy. I don't know who voted what. So did the county violate the law? Okay, we're at 50%. So let's move forward. Thank you all for participating. And here's the split. We have the majority of you thinking that the county violated Florida law by disciplining the firefighter EMT for his lawful off-duty use. Interesting. So let's see where this case settled. Did the court side with the employer that despite a clean record, no impairment, and full compliance with state law, they had the right to suspend the employee over a positive marijuana test? Not even close. So here is why. The court ruled in favor of the employee on all four of his claims and didn't mince words. First, it confirmed that the employee was a qualified medical marijuana patient under Florida law. Conditions like anxiety and insomnia were recognized as protected disabilities under the Florida Civil Rights Act. Then it turned to the county's own drug-free workplace policy and union agreement, both of which said positive drug test results could be explained with a valid state or federal prescription. The employee did exactly that. It presented documentation on time as required by policy, but the county ignored it. The court also rejected the argument that federal illegality trumps state protections. Remember, they said that marijuana is federally illegal, so it doesn't matter. This was a state level case, and in Florida, medical marijuana is legal and it's constitutionally protected. What about the claim that the employee didn't request a workplace accommodation? The judge didn't buy that one. The employee didn't need one. He wasn't impaired, wasn't using it at work, and was performing his duties just fine. He simply wanted to manage his health off the clock like any other employee using a prescription. So here's the bottom line. The employer violated state civil rights law. They ignored their own policies, and they now owe this employee back pay, damages, and attorney's fees. So what's the lesson that you can learn from this? If your policy says that you'll consider valid prescriptions, that has to include cannabis, at least in Florida, or you could be headed for court. Really interesting case here, especially since Florida didn't used to consider accommodation of medical marijuana as part of its own statute. But now, as a result of this case, I'd arguably say it does. So that is our audience participation. I really enjoyed this. I hope you did as well. All right, as we wrap up, here is our cannabis compliance playbook. First, focus on workplace impairment rather than zero tolerance policies for off-duty cannabis use, especially in states with evolving marijuana laws. Second, update those testing methods in states like California and Washington, where pre-employment testing for THC is restricted. Switch to oral fluid testing or remove THC from your drug testing panels. And if you hire in Philadelphia or Pittsburgh, make sure that you either ask candidates if they're medical marijuana users post-offer or remove THC from your pre-employment drug testing panels immediately. It's not permitted. Here is your call to action. Employers need to make sure your drug testing policies, practices, and screening panels align with these evolving regulations. Third, speaking of which, know the law. Make sure you understand state-specific regulations on both medical and recreational marijuana. And remember that all marijuana legalization laws exempt federally regulated and safety-sensitive positions. And that's our cannabis update. Keep getting your questions in using the Q&A icon at the bottom of the screen. We are having great interaction here. Nicole, you're doing a great job. Check out the resources section of the webinar for more information, and let us know if you need help adjusting your drug testing panels or if you'd like any information on oral fluid screening. All right, let's shift gears. I'm going to motor through some quick updates on privacy, tech, and employment laws that you'll want to keep on your radar. First off, take a look at this map. It shows all current and soon-to-be effective state data privacy laws. Recently passed laws are marked with a star, and those becoming effective in 2025 are shown in aqua. So far, this year, no new privacy laws have been enacted. One important reminder, all comprehensive state privacy laws exclude data covered by the Fair Credit Reporting Act, the FCRA. That means background checks conducted by providers like HireRight are not subject to these laws. They remain governed by the FCRA, so nothing to worry about there. And here's a look at the data privacy bills that we're following in 2025. All bills maintain that FCRA exception that I just discussed, exempting background checks. Again, we're going to keep monitoring for these for you, but as of now, no concerns with state data privacy laws as it relates to that FCRA exception. And here is a map that tracks the progression of AI laws affecting private sector employers, a landscape that is rapidly evolving. Several states have introduced laws regulating AI in hiring and employment decisions, have actually passed these laws. So in New York City, local law 144 requires employers to conduct annual bias audits on AI hiring tools and disclose their use to candidates. In Illinois, their AI Video Interview Act mandates notifying applicants when AI is used during interviews and obtaining their consent. Other states like Utah and California are enacting transparency laws to regulate generative AI. And one standout is Colorado's AI Act. It's the first cross-sector law targeting high-risk AI systems, including those used in employment decisions. I love talking about AI, and I've covered it heavily. You're going to find several articles in this webinar's resources section, so check those out if you want to know more about what's going on with AI and employment decisions. Let's take a look at what's happening at the federal level on AI. On the screen is a comparison I put together for you of the Biden and Trump administration's approaches to AI regulation. You're going to see that they look very, very different. Under Biden's Executive Order 14110, the focus was on safe, fair, and transparent AI, especially in the workplace. Agencies like the EEOC, OFCCP, and the Department of Labor issued guidance to prevent bias, encouraged audits, and required notice to individuals affected by automated decisions. In contrast, the Trump administration revoked that order in January 2025, calling it burdensome and a barrier to innovation. So the new policy under the Trump administration takes a deregulatory approach. It prioritizes rapid AI development and global competitiveness. The administration wants to make the United States the leader in global AI deployment. A new AI and crypto czar, David Sachs, is leading the charge to create a national AI innovation plan. So what does all of this mean for employers? First off, I would say that federal oversight has loosened, but that doesn't mean that you're off the hook. Civil rights laws still apply, and many states and cities are moving forward with their own AI rules and regulations. So the bottom line here is that even if federal rules scale back, anti-discrimination compliance obligations remain. They've just shifted to the state and local level. So employers using AI for hiring or HR decisions still need to be careful, transparent, and proactive. If you're interested, there is a link to the White House's press release on Trump's executive order in the resources section. It's an interesting read as it gives you kind of a path towards AI and innovation under the administration. So let's move on to some state level activity, starting with New Jersey. Their new guidance signals a big shift in AI compliance. It's no longer just about the technology, it's also about accountability. Much like New York City, their local law 144 that I mentioned earlier, employers in New Jersey are now responsible if their use of AI leads to discrimination, even if a vendor built the tool that they're using, and even if the employer doesn't fully understand how it works. The guidance outlines areas where risks can arise. Those include the tool's design, the data it's trained on, and how it's used in practice. So if you're relying on vendor supplied AI for hiring in New Jersey, make sure you understand how it works and ensure it's not creating discriminatory outcomes. And here's my AI legislation tracking map. In 2025, states have introduced a wave of bills to regulate how AI is developed and used, especially in high stakes areas like hiring, housing, and credit, those critical decisions that lawmakers are focused on. Most proposals target high risk AI systems. Those are systems that influence major decisions and share common themes. Um, Lawmakers are interested in impact assessments, transparency, anti-discrimination safeguards, and long-term documentations as to how these tools operate. One standout for me was Virginia's bill, which offered clear, balanced oversight, mostly aligned with our industry's expectations. Unfortunately, it was ultimately vetoed, with the governor commenting that the bill had a potential to stifle innovation within Virginia. So passed by lawmakers, vetoed by the governor. Here's the takeaway for employers. If you're using AI in hiring, now's the time to ensure that the tools are transparent, that they are auditable, and that they include meaningful human review. Keep humans in the loop with those critical decisions. That's what lawmakers want to see right now. I think this is really interesting. Let's talk about a big development out of New York that could set the stage for a broader national trend, especially for employers using AI in workforce management. First, a quick refresher. The WARN Act requires certain employers to give advance notice of major workforce changes, things like layoffs, closures, or relocations. Federally, it's 60 days notice of those mass layoffs, closures, or relocations, but New York's version is more strict. It requires 90 days and it covers more employers. Now, here's the update. In her January 2025 State of the State address, Governor Kathy Hochul announced that the New York Department of Labor will amend its WARN regulations to require employers to disclose whether AI influenced a layoff or restructuring. This is a first. No other state has a proposal linking AI use to WARN notices. Again, in New York, you would have to amend your WARN notices to disclose whether AI influenced a layoff or restructuring. Really interesting. The goal is to gather real data on how AI impacts job decisions. While the details are still emerging, it adds what I'd consider a new layer of transparency for employers using AI in HR or operations. So what does this mean for you? If you are using AI for performance monitoring, workforce planning, or predictive analytics, you may soon need to assess and disclose how those tools contribute to workforce reductions. It also is a signal. Lawmakers are starting to view AI not just as a compliance or bias issue, but as a driver of what I'd consider economic disruption and job loss. So pay attention to what's going on at New York, and let's see if this ends up taking more hold nationwide. Let's wrap up our look at AI privacy and employment with a few takeaways from the Compliance Playbook. First, it's important to remember that FCRA regulated background check data is exempt from state data privacy laws. So while privacy regulations are expanding, this data remains carved out under federal law. Next, audit your automated decision-making tools. With new anti-discrimination guidance under New Jersey's law against discrimination and emerging AI laws in places like Colorado, Illinois, and New York City, employers need to ensure these tools are not introducing bias or used in ways that could create legal exposure. We're also seeing a shift in federal AI priorities. The Biden era focus on fairness, transparency, and worker protections is giving way to a Trump era emphasis on innovation, deregulation, and economic competitiveness. That change in tone should prompt a reevaluation of AI strategies in the workplace. Finally, track AI legislation in key states like California, Massachusetts, Virginia, and Texas. These states have active bills that could reshape how employers use AI in hiring, with New York potentially leading the way by trying to use AI, by trying AI by trying to tie AI to WARN Act layoff disclosures. Again, really interesting in New York. These changes underscore the importance of staying proactive and agile when it comes to AI compliance, a quickly evolving area and an area that I love talking about. Let me know if you have any questions as we wrap and move on from this section. We have time for 2 quick updates concerning I-9 and E-Verify, and let's dive right in. So there are some small but important updates to Form I-9 and E-Verify. USCIS released a new version of Form I-9 dated January 20th, 2025, with an expiration date of May 31st, 2027. Key changes include the 4th checkbox in Section 1. It now reads an alien authorized to work, updated to match statutory language. There are 2 List B documents that have revised descriptions, and the DHS privacy notice and instructions are now more legally precise. You can still use the August 1st, 2023 version, but be aware some systems mistakenly show an expiration of July 31st, 2026. If that's the case, you need to update it by then to avoid any compliance issues. On the E-Verify side, starting April 3rd, the system now aligns with the new I-9 language. So even if an older form says non-citizen authorized to work, you'll need to select an alien authorized to work when submitting. This update applies across E-Verify, E-Verify Plus, and any web services. The system will relabel the status automatically, even if the original form uses the old wording. No changes were made to the interface control agreement. That's version 31.1, but developers should update terminology where possible. So the bottom line, these are some minor tweaks, but they reflect a broader push for statutory consistency, and it's really smart to stay ahead of them in today's increased enforcement climate. Speaking of which, let's take a look at how immigration enforcement is shifting under the Trump administration and what that means for employers. On day 1 of the Trump administration, several executive orders were issued declaring a national emergency at the southern border, expanding deportation priorities, ramping up ICE worksite presence, and cutting funding for sanctuary jurisdictions. The message is clear. We're seeing a return to aggressive enforcement, more I-9 audits, and surprise site visits, steeper penalties for noncompliance as well. So what can you do to prepare? So start with your I-9 process. Make sure you're completing Section 1 by day 1 and Section 2 within 3 business days. Physically inspect those documents and store I-9 securely and separately from personnel files, and conduct internal audits and train your HR teams. Check your E-Verify compliance. Keep accounts current and ensure users require the required tutorials. Display participation and rights posters in English and Spanish, and be ready for a site visit. You can do that by designating and training point of contact staff, making sure employees know their rights, including the right to remain silent and request an attorney, and notify your legal counsel immediately if agents show up. And don't overlook the penalties. In 2025, I-9 violations and knowingly hiring unauthorized workers can carry fines of up to $30,000 per violation. Misusing E-Verify can get your organization removed from the program and referred to enforcement. The bottom line is now is the time to review your I-9s, refresh your policies, train your teams, and loop in your legal counsel. In today's enforcement environment, proactive compliance is a must. So let's turn to the Compliance Playbook for Form I-9 and E-Verify. First, make sure you're using the latest version of Form I-9 dated January 20th, 2025. Even though previous editions remain valid for now, systems must reflect the updated expiration date of May 31st, 2027. So get that done by July 31st, 2026. Next, starting April 3rd, 2025, employers must update E-Verify case status creation to reflect the revised citizenship status and alien authorized to work. This change applies to both E-Verify and E-Verify Plus submissions. HireRight customers, we are working on implementing these changes to our platform. So again, you should expect to receive a customer communication with more details, but know that we're working on this. And finally, plan for more aggressive immigration enforcement. With a shift in administration priorities, we can expect to see an uptick in audits, site visits, and penalties in 2025. Keep all of these items on your radar and in your compliance playbook. Just a reminder, we have several outlets of information for you to consume. So if something piqued your interest, check out our resources library, blog, and Forbes articles to learn more. And again, snap that QR code and connect with me on LinkedIn, where I post a short video covering new compliance topic every week. So with that, that wraps our prepared content for today's webinar. As I mentioned earlier, we're keeping the conversation going with a brief after hours Q&A session. If you joined us for SHRM or HRCI credit, you've met that 1 hour attendance requirement. You're welcome to drop off whenever you're ready, or you can hang around. But before you go, please take a moment to complete that survey. Your feedback is truly valued. I consider it my report card, and it helps shape future sessions. You'll receive an email next week with your credit information and a link to the webinar recording. For those of you sticking around, let's jump into those questions. We're going to keep this Q&A short and focused, no more than 10 or 15 minutes. But let's get into that Q&A. Nicole, do you want to open things up with a kind of summary of what you've seen so far, and then we can get into some questions live?
Sure. Yeah, there's some really great questions, some really good themes that I want to talk through and let you talk about a little bit more. The first one that I've gotten quite a bit that I think would probably be helpful if we just touch on really quickly now is how to know which law applies. Does it apply where the candidate lives, or does it apply where the candidate works? And we got these questions across every section you went through today.
Yeah, it's a great question, and it's a question we often receive. And of course, we have to provide the most lawyerly of lawyerly answers. It depends. That said, and the reason I say that it depends is because some statutes, some laws, regulations, ordinances specifically define the scope of the law. It will tell you that if it applies to individuals working in a particular jurisdiction or living in a particular jurisdiction, or maybe both. Generally speaking, though, I think a good rule of thumb is tying these laws to workplace. So if an individual will work in a particular jurisdiction, then at minimum, you should attempt to comply with that particular law, regulation, or ordinance. For those of you using our compliance workbench tool, for example, which helps you facilitate your ban the box obligations, the compliance workbench will typically align itself with where an individual is working. So for example, if an individual is going to work in, let's say, Los Angeles, and they have criminal history, it'll flag that as being subject to the Los Angeles ban the box law. So I think a rule of thumb, again, at least follow workplace, but you can certainly choose to be more expansive. And if you're really concerned, reach out to your legal counsel and take a look at those particular statutes, laws, regulations, or ordinances. Anything you'd add there, Nicole?
No, I think that covers it pretty well, pretty thoroughly. Before we get into too many more content questions, we've gotten a lot of questions about the QR code. Folks are looking to scan the code. So can you throw that back up on the screen for everybody?
Yep, let me push that. So that QR code is at the bottom of the screen. Again, you can also take a look at that link. I've also included a link within that companion document to today's webinar. So at the bottom of that companion document, you can find me and follow me on LinkedIn. Again, I post weekly compliance-related content. So if you want a quick 60-second snapshot of what's going on that may affect your background screening program, take a look at those videos, read those articles, and engage with me on LinkedIn. Always happy to engage in a conversation. Thanks so much for your support.
All right. One other major theme that we got that I think we probably won't have time to get into too much today, and we may not necessarily be the best experts to talk about anyway. We've gotten a lot of questions about drug testing, reasonable suspicion programs, random testing programs, all of those things, and best ways to implement them, best types of specimens to use. So I think for those, my recommendation would be to keep an eye on our website, keep an eye out for the webinars and blog posts that Dr. Todd Simo does. He knows significantly more than I do, at least, about all of those things. So if you're looking for information on kind of how to structure your program and what types of drug testing specimens may be best, I would keep an eye out for those. I think that's going to be where you'll get the best information. But Alonzo, anything to add on those ones?
Just that we will certainly share your questions with our drug and occupational health screening services team, including Dr. Simo, and get some information back to you. If it's warranted, we can certainly have the team put together a brief communication that summarizes some of those issues. But thank you for getting those questions in. Drug testing is certainly a very complex area, especially things like random drug testing. So yeah, we'll get those over to the experts.
All right, on to the next question. This is one, Alonzo, that you and I think, talk about quite a bit, actually. And it's a really, really good question. For jurisdictions where individualized assessments are required, or really any other type of specific ban the box or fair chance process towards the end of the screening process, is it considered best practice to have written policies and guidelines to kind of guide that decision-making, guide that assessment, and really guide that whole process?
So while this is, really a question that you'd want to engage your legal counsel in, I think generally all employers should maintain background screening policies. So these would be high-level policies that speak to the nature of the scope of your background screening, why you're doing what you're doing, and how you're ultimately making decisions on that information. Your process documents can certainly dive into how you're actually adjudicating background checks in greater detail. But at minimum, I would say that your background screening policy should reference the green factors. These are the individualized assessment factors that are mentioned in the Equal Employment Opportunity Commission, the EEOC's 2012 guidance to employers on the use of arrest and conviction records. If you're interested, I don't think I linked to it in this particular webinar. I always do, and I think it's an omission on my part. But if you Google EEOC guidance to employers based on arrest or conviction records, and I should be agnostic, not just Google, you can use any web search tool that you want to. You will find that document out there. Again, take a look at it. It specifically outlines the process that you should go through when evaluating an individual's criminal history, including looking at the nature of the offense, its relation to the job, the time that's passed since the events, any evidence of rehabilitation, such as having performed a similar position in the past, and use all of that information, the individual's age at the time of the offense as well, use all of that information in making your decision. But yes, absolutely, you should have a background screening policy and process documents that speak to how you handle your program.
Excellent. Okay, a couple more questions on the scope of some of these laws and when they apply and how they work. First, with Clean Slate, we've gotten a couple of questions on how Clean Slate relates to driving records. So if someone is convicted of a DUI, is that going to expunge it from their driving record if it's subject to Clean Slate? Or is it only from court records?
Yeah, great question. So generally speaking, motor vehicle records will remain untouched unless a clean slate law specifically contemplates amending a motor vehicle record. But to the best of my knowledge, and I should mention, caveat to our audience, I haven't taken a deep dive into this, but based on my kind of cursory review of all clean slate laws, I can't think of a single one that specifically talks about altering motor vehicle records. So that said, you should expect to see any of these minor traffic-related misdemeanors or infractions still reported on MVR reports. But I think, like the audience is kind of intimating here, there could be a disconnect between what you see in criminal records and what you see in MVR reports. Because if a particular jurisdiction does consider traffic offenses to be misdemeanors, and those misdemeanors are subject to a clean slate law, they will be sealed or expunged, but they will still continue to appear in an MVR report. So great question. And yeah, recognize that clean slate laws generally don't apply to motor vehicle records.
Excellent. And then I think the last of our kind of scope questions are more general questions that I got quite a bit, and I just want to make sure we cover for the whole group who are still here. For Massachusetts and for Cleveland, so Massachusetts for their pay data reporting law is 100 employees. Cleveland is 15 for their pay-related law. The question that we've gotten quite a few times is that a total number of employees or just a number in that particular jurisdiction? So 100 in the state of Massachusetts and 15 in the city of Cleveland.
So with respect to Cleveland, that is within the city of Cleveland. With respect to Massachusetts, I need to dig into the law. I believe it is 100 employees overall. I believe it aligns itself essentially with the federal EEO reporting standards. So 100 employees overall would be subject to Massachusetts pay data reporting law. We can certainly validate that. Again, I've linked to the statute in the companion document for this webinar, so you can review it right there. Again, I think from a safety perspective, I would say it aligns with federal law, so it would be 100 employees overall.
Right. Another one that I think we've talked about quite a bit in the past, remote jobs and all of these different laws we're talking about, specifically pay equity type laws. So we have a few people who are asking, what is best practice when you're thinking about job postings and when you're thinking about pay equity kind of as a broader topic when you have a lot of remote positions, you have people who may live in different states working for a company all in the same place?
Sure. So, I mean, I think with pay equity laws in general, so let me answer the question by not answering the question first. So I think with respect to pay equity and pay transparency laws in general, employers could choose to take a holistic approach to compliance. Because pay equity and pay transparency laws can be relatively nuanced, we've seen a lot of employers, especially in the mid to larger size arenas, choose to adopt pay equity and transparency holistically, meaning that they're providing pay ranges across the board for transparency purposes, and meaning that they are no longer asking individuals to disclose their former compensation history across the board, regardless of whether or not a jurisdiction requires that. Now, focusing on the question itself with respect to remote workers and how these laws might apply to them, again, I generally believe that work location is key here. And you're going to ask, well, what's work location for a remote worker? And you know, the piece of guidance that I typically provide to employers is to kind of look at where you are associating that particular worker with for tax purposes. So, for example, if you are associating an individual who lives in Denver, Colorado, but works remotely for you in Cleveland, Ohio, where you're based, but the individual is domiciled and will work in Denver, Colorado, and for tax purposes, you are paying taxes in Colorado, and specifically occupational taxes to the city of Denver, then I would say that they're probably a Denver, Colorado employee. So you'd probably want to align yourself with the laws, ordinances, regulations of that particular jurisdiction. Very nuanced question. Generally speaking, tax location is a way to go, but some employers, with the advice of their legal counsel, may choose different options, such as where an individual typically will report into, if they go into an office on maybe a hybrid occasion. But again, generally, I think where the individual lives is probably where they're working and where the law would apply.
Makes sense. All right, let's switch to cannabis laws. We have kind of a whole bunch of different questions that really all relate back to a pretty similar theme. Are there exceptions within these cannabis laws for either safety sensitive or DOT positions, or for federal government contractors? We've gotten a lot of these.
So let's talk about federal government contractors and DOT positions first. So there are exceptions 100% of the time for any federal contractor. So any individual who is subject to a federal contract, federal bonding, or federal funding, which would include DOT regulated positions, would all be exempt from the scope of any marijuana cannabis law. Safety sensitive is not as straightforward. Some regulations provide exceptions for safety sensitive positions as defined in that statute. Others say that you can supply a position description to that statute's regulator, and that regulator will determine whether or not that position falls into a safety sensitive position. So the bottom line is there is no comprehensive answer for safety sensitive positions. You're actually going to have to look at the statute and determine whether or not that position qualifies under that particular statute, whether or not you may need to speak to a regulator or not. It's really, really complex. If you have specific jurisdictional questions, feel free to ask, and we can follow up with you afterwards. But again, this is probably one of those spaces where you're going to want to engage your legal counsel if you have specific questions about the applicability of a safety-sensitive position and an exception to a cannabis law.
Excellent. Definitely not a straightforward, easy one.
I wish it was, but it's not. No, and in fact, I will just say that Philadelphia, for example, offers no carve-outs for safety-sensitive positions, which is, really, I mean, it's hard to believe that that is the case, but they are one of those places where they say you need to talk to the regulator. So, again, it really depends.
Yeah, a lot to think about. All right, let's do a couple I9 and E-Verify questions before we wrap up. Couple questions on I-9 for remote workers and whether remote verification of Form I-9 is still allowed.
Yes, so if you'll remember, during the COVID-19 pandemic, the USCIS established a process for remote verification, essentially where you did a web meeting with an individual, right? A web conference, and you review their documentation. They've continued a hybrid version of that practice. So there is guidance available on the USCIS's website that can take you specifically through that hybrid process. You have to use E-Verify as well, though, to use that hybrid process. But there is a remote verification, I should say a virtual verification process still made available to employers, as well as a remote verification process where you can have an agent of yours, for example, visit that particular worker and verify their documents in person. So both remote in-person verification and virtual verification available. All of those details are available at the USCIS's website. If you need directions to that particular website, just let us know.
Right. And the next question we've gotten quite a bit for current employees who already went through the I-9 process. Do employers need to go back and now get a new I-9 now that we have a new I-9 form?
No. If you completed an I-9 and you completed it accurately as required at the time you completed that I-9, you absolutely should not go forward and get a new I-9. Doing so would cause a lot of compliance issues and confusion within your program. So no, if you have a valid and compliant I-9 at the time you completed that I-9, do not get a new I-9. Again, direct any I-9 related questions to your immigration counsel. This is a very strange time as it relates to enforcement, so you want to make sure you get that process right.
All right, and I think the last question that we've gotten several times, so I just wanted to make sure to cover on E-Verify. Is it required? Do employers actually have to do E-Verify, or is it just a nice service that's made available that they can use if they choose to do so?
For most employers, it is completely optional. So most employers do not need to use the E-Verify service. They can use it if they choose to. The exception being employers who are regulated by a particular statute, whether that be at the federal or state level, to complete the I-9 process. Also, all employers in the state of Florida have to use the E-Verify process now. I believe Florida is the only state that has imposed such restrictions. Florida, for what it's worth, also has a lot of state level immigration related laws that exceed the federal level. So if you're a Florida employer, definitely make sure you engage your immigration counsel and I-9 counsel as it relates to compliance with laws there. But the short and fast of it is no. For most employers, E-Verify is completely optional. All right. Well, Nicole, thank you so much for your help today. And to our audience, thank you for the engagement. It has been absolutely amazing. We sincerely appreciate your questions and discussion. So with that, that is a wrap for today. As a reminder, this webinar will be available soon in the HireRight Resources Library. You'll receive an email next week with your SHRM and HRCI credit details. Again, thanks so much for spending a part of your day with us. Before you head out, please take just a minute to complete the survey. Your feedback is incredibly valuable and helps make these sessions even better. I hope to see you again in July for our Q2 compliance webinar. Until then, stay connected through Forbes, the HireRight blog, and LinkedIn. On behalf of Nicole, myself, and everybody at HireRight, thanks again. We appreciate you.